Hello everybody. Let's talk about some final related concepts on the nitty-gritty basics of objections. Occasionally it's necessary to ask for a continuing objection. If your strategy is such that you think it's a good idea to object, but there's a long list of questions and answers that you want to object to, you may want to ask the judge for a continuing objection. And this way minimize the annoyance that the jurors will inevitably feel when you object many times. Sometimes you cannot reasonably anticipate what the answer was going to be from the question. If that happens, you should interrupt, objection, and move to strike the answer. Think of what you're doing in opposing a witness, or even as you present a witness, as a scrolling electronic transcript. That transcript needs to be crystal clear to the appellate court that you objected to certain answers or questions or whatever the case may be. So you need to speak to the transcript to make crystal clear objections so that if you lose, your client's appellate rights can be fully protected. Anything that is a potential exhibit that the judge excludes, you should make sure to mark it for identification. Usually something like A, B, C, D, or E, something along those lines. You should mark excluded items for identification, but you should not bother with a preliminary step of marking things for identification that you know are going to get into evidence. It's just an unnecessary, time-consuming step. Sometimes if you are the opponent of exhibits and they're admitted over your objection, you need to repeatedly object. So, for example, you might move in limine to exclude a defendant's confession. When that confession is offered again, after your objection and your objection is overruled and your motion in limine is denied, if that confession is offered during the trial, then you should object again. Not always necessary as a strict legal matter, but a good practice to do, a nice, respectful, friendly objection made to protect the record. Make your objections as specific as possible because it is a trial lawyer's job to protect the record on appeal. Thank you.